So this is part one of federal securities laws. This topic is covered on both the multiple choice and task-based simulations on the CPA exam. It's a significant area of accountants' legal liability for purposes of the CPA exam. You're going to have a general understanding of the Securities Exchange Acts of both 1933 and 1934. Interstate commerce is the reason the federal government is allowed to step in and apply this federal legislation. I wanted to note to you that interstate commerce is very easy to find according to court interpretation. So for example, courts have held that interstate commerce is present when you just have a telephone call between residents of the same state, not even different states, but the same state. So let's get started. So basically, these Securities Acts have two purposes. The first is full and fair disclosure. So full and fair disclosure of all relevant information. So that includes financial statements and such other information such as the description of the management. However, I also need to mention that the Securities Exchange Commission does not rate securities. The federal securities laws require that these disclosures are made and it be a full and fair disclosure, but the Securities Exchange Commission does not rate these the federal securities. So a prospectus must be supplied, and the prospectus does provide relevant information. I'm going to define prospectus a little bit better in a minute, but for now, a prospectus is any notice or circular or advertisement, letter or communication offering a security for sale. A prospectus may be written, it may be an ad on the radio, or even on television, unless a written prospectus has already been sent or the ad says that a written prospectus is available. So the second purpose of the Securities Act, so in addition to full and fair disclosure, is that the acts prohibit unfair, deceptive, and manipulative practices. The Securities Exchange Act of 1933 is also known as the Truth in Securities Act. This act regulates the sale of securities in the primary. So when a security is initially issued, the primary securities market. The 34 Act regulates the sale of securities in the secondary market. So according to the 1933 Act, securities may not be sold to the public until there has been a registration with the Securities Exchange Commission, unless an exemption applies. All right, so let's look at what is a security. So does a security have to be a piece of paper that's called a stock? And the answer to that question is no. The Supreme Court of the United States has held that substance wins over form. So watch out for a fact situation involving an investment whereby the owners hope to make a profit solely through the efforts of others. All right, so this example is based on the Howey case, and now we have the famous Howey test. So watch out for an example like this. So suppose ABC sells rows of orange trees. They also obtain contracts to care for and to pick and to sell these oranges. Is this a security? The answer to the question is yes, it probably is a security because the owners hope to make a profit solely through the efforts of others. And this example is based on the real case of the Securities Exchange Commission versus Howey, decided by the Supreme Court a long time ago, 1946, and it established this now famous Howey test. So the Howey test is as follows. I'll read this to you. An investment contract for the purposes of the Securities Act means a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. So let's look to see how this Howey test has been applied in our circuit. And this is the case of Teague versus Bakker. Now, this man, Mr. Bakker, was a famous television evangelist. And this case, as I said, arises from our circuit. So he opened a Christian theme park, and it was known as PTL's Heritage USA. And I'm going to read to you what he offered people who invested in Heritage USA. The promotional material said this, and I'm reading from his promotional material. You cannot find a better investment opportunity anywhere. You can actually save thousands of dollars during your lifetime with your one-time investment of $1,000 in the ministry of PTL. The brochure went on to say that for a one-time gift of $1,000, you'll be able to stay free for 4 days and 3 nights every year for the rest of your life in the Heritage Grand Hotel. And it went on to show that with the current rate of inflation, this could be worth $20,000. So the question is this a security? Are you hoping to make a profit solely through the efforts of others? And the Fourth Circuit applied the Howey test, and they said, yes, indeed, it is a security and subject to the Securities Exchange Commission regulations and rules. So what are the disclosure requirements under the 1933 Act? So let me show this to you make it a little bit bigger for you to see. So the disclosure requirements under this act are exhaustive, and they're very expensive to comply with. So for that reason, public financing of small businesses really was not a viable option. And to be honest, still isn't in many cases. So to resolve this problem, the 1933 Act and the Securities Exchange Commission regulations provide a number of exemptions from full-blown registration with the Securities Exchange Commission, so that if you meet one of the exemptions that I'm going to go over in just a minute, then you do not have the costly registration requirements. So let's look at some of the exemptions that you could qualify for. The first exemption is a short-term commercial paper maturing in less than 9 months. The short-term commercial paper has to be used solely for working capital, not plant and equipment. So what if the notes are used for plant and equipment? Do you think the exemption will apply? And the answer, of course, is no. Insurance and annuity contracts are also exempt from registration. Stock splits are exempt from registration. Reorganizations under the Bankruptcy Act are also exempt from registration. But what I will tell you is that a merger is not exempt, because a merger is considered to be a sale. Regulation A, this includes issues of up to $5 million. If you qualify under Regulation A, this is also a relatively simple registration by the issuer. Intrastate sales also are exempt. So here's the deal with an intrastate sale, though. All the purchasers, and not only all the purchasers, but all the offerees, all of the people to whom the shares have been offered, have to live in the state where the corporation is doing business. The other thing to remember, if you're trying to qualify under the intrastate sales exemption, the purchasers cannot resell the stock to a non-resident for 9 months. So there are restrictions on resale. Closely held corporations, charitable organizations, and governmental entities and banks are also exempt. Certain transactions are exempt under Regulation D. Regulation D has 3 rules that you need to be familiar with so that you can pass this part of the CPA exam. And the first is Section 504. So these, before I go any further, let me note to you that these securities under Regulation D are considered to be restricted, and they may only be sold after they have been registered. All right, so the first exemption is called a seed capital exemption under 504. With a seed capital exemption, you do not need a full-blown registration with the Securities Exchange Commission. But the thing to remember is that the sale may not be advertised. And so you would have to go out and solicit people to invest in your business without any sort of advertising. Again, this is known as the seed capital exemption. Section 505 covers offerings of less than $5 million. And again, you would not have to make a full-blown registration provided the stock is sold to accredited investors. And I'll define that in a minute. And up to 35 unaccredited investors. So an accredited investor would be a bank or an insurance company or someone whose net worth is greater than $1 million or whose income, annual income exceeds $200,000 for an individual and $300,000 for a married couple. Again, with a Section 505 exemption, advertising is not permitted. And for purposes of the CPA exam, if there is a 505 or 504 exemption, just remember that less than a full-blown registration under the 1933 Act is required. Section 506 is another exemption under Regulation D, and it allows for private placement of an unlimited amount of securities. So unlike 505, 506 does not have any sort of monetary restrictions. However, the other unaccredited investors, and that is up to 35, must be sophisticated investors capable of evaluating investments on their own or who have a knowledgeable representative. As with 505, advertising is not permitted. And so there is also a casual sale exemption. And so a casual sale exemption is a sale by someone who is not an issuer, underwriter, or a dealer. And a casual sale exemption is also exempt from registration. By the way, just in case you don't know, an issuer is a corporation or a partnership that's issuing securities. And an underwriter is someone who purchases securities with the purpose of reselling them and has no intention of actually investing in these shares. So if no exemptions apply, then the 1933 Act is applicable. And so the 1933 Act requires a registration statement, and a registration statement includes a prospectus, and this must be filed with the Securities Exchange Commission. The registration statement does not become effective until the 20th day after filing. And so what I will tell you about this is that what generally happens is that the registration statement has some sort of a deficiency, and you are given the opportunity to correct that deficiency. But what happens is that it starts the clock all over again. So the process could take months, and I will tell you generally it takes 40 days for the process to run its course. During that period of time, while you're waiting to see if all the boxes have been checked, it is illegal to sell securities. Written offers are also prohibited during this period of time. However, you may use what's known as a tombstone ad. And a tombstone ad is called a tombstone ad simply because the ad has a black border around its edge. Essentially, a tombstone ad is an offer that includes a disclaimer that says that it's not an offer. Tombstone ads tell the world that a prospectus is available. As a general rule, a prospectus is simply a condensed version of a registration statement. Also need to mention that anti-fraud provisions apply as long as interstate commerce is used, and I think it's fair to assume that interstate commerce would always be used in this case. So let's look at some questions, and let's see if you can solve these. So the first question is this. So a preliminary prospectus is permitted under the Securities Exchange Commission regulations, and a preliminary prospectus is also known as a red herring prospectus. Red herring, I don't know if you're familiar with that term, but the term is hundreds of years old. A red herring was something that a criminal used to, when he was being pursued by the law, to escape the hounds who were also with the sheriff or whomever was chasing the criminal. So what a criminal did was they put this really smelly fish on the end of a rope and they dragged it behind them to throw the hounds off their scent. Anyway, a preliminary prospectus permitted under the Securities Exchange regulations is also known as a red herring prospectus. Question 2, under the Securities Exchange Act of 1934, which of the following types of instruments is excluded from the definition of a security? And the answer here is a certificate of deposit. Certificate of deposit, as you may recall from commercial paper, is a special type of commercial paper that's issued by a bank. All right, so question 3, a tombstone advertisement. A tombstone advertisement, the answer to the question is D. So not only does it have a black border around it, it makes known the availability of a prospectus. And remember, a prospectus is essentially just a condensed registration statement. So D is your answer. And then 4, under the Securities Act of 1933, which of the following statements most accurately reflects how securities registration affects an investor? And all right, so if you look at these possible answers, you know that C and D absolutely are not true. So the investor is guaranteed by the SEC that the facts contained in the registration statement are accurate. That's not true. They should be accurate, but that is not true. And then D, the investor is assured by the SEC against loss resulting from purchasing the security, and that is not true either. The Securities Exchange Commission does not rate investments. All right, so now we're down to A and B. And so A is the investor is provided with information on the stockholders of the offering corporation, and that's not true. And so B is your correct answer in this case. The investor is provided with information on the principal purposes for which the offering's proceeds will be used. And so B would be your correct answer here. So let's move on and look at the next question. So questions 6 and 7 are based on the following facts. Sandy Corporation is considering the following issuances. 1, notes with maturities of 3 months to be used for commercial purposes and having a total aggregate value of $500,000. 2, notes with maturities of 2 years to be used for investment purposes and having a total aggregate value of $300,000. And 3, notes with maturities of 2 years to be used for commercial purposes and having a total aggregate value of $200,000. Which of the above notes is or are exempt securities and need not be registered under the Securities Act of 1933? And your answer here is one only, right? So A is your answer. And then 7, which of the above notes is or are subject to the anti-fraud provisions of the Securities Act of 1933? And all of them are subject to the anti-fraud provisions of the Act. So your answer is 1, 2, and 3. And so D is your correct answer. So question 8. Which of the following is not a security under the definition of the Securities Act of 1933? And so let's look at your choices. So your choices are any note, and then B, a bond certificate of interest, and then C, a debenture. And the answer is all of these are considered to be securities under the Act, so your answer to this question is D. And then 9, which of the following requirements must be met by an issuer of securities who wants to make an offering by using a shelf registration? Well, with a shelf registration, the actual issuance is going to take place over a long period of time. And so the original registration statement must be kept updated, and the answer is yes, it does need to be kept updated. And how about this? The offer must be a first-time issuer of securities, and there's no such requirement. And so your answer to this question is B. So yes to the original statement, registration statement has to be updated, and no, you don't have to be a first-time issuer of securities. And then next question, the last two for the first half of this module, question 10. So which of the following securities would be regulated by the provisions of the Securities Act of 1933? And so, so your choices are securities issued by nonprofit charitable organizations, no. Securities guaranteed by domestic governmental organizations, and the answer is no. Securities issued by savings and loan associations, and the answer there is no also. And then lastly, securities issued by insurance companies, and that is your answer. Insurance companies, yes, they are subject to this act. And then finally, last question for the day is, which of the following securities is exempt from registration under the Securities Act of 1933? And the only one that would be exempt from registration is B, a class of stock given in exchange for another class by the issuer to its existing stockholders without the issuer paying a commission. And so that is the answer. So next class, what we will do is we'll focus on the Securities Act of 1934, and the questions that I'd like for you to look at in connection with this material include questions 15, 17, 19, 21, 23, 25, 28, 30, 32, 34, 36, 37, and then lastly 43. Thank you.